Assalamu alaikum, and welcome back to True Courtroom Stories. This is episode 76, and we're diving into the incredible history found in the book True Courtroom Stories, researched by Mr. Zahir Ahmed Mir. Today, we're going to travel way back in time, over 1,000 years, to a truly revolutionary moment in legal history. We're going to explore how one incredible judge in the 10th century Fatimid Caliphate built a justice system that was so advanced, so far ahead of its time, it would take centuries for the rest of the world to even begin to catch up. So let's get right into it. But first, let me ask you something. What if the rules of justice were a complete secret? Seriously, what if the laws that governed your life, your property, your family, your freedom, were totally unpredictable? You know, changing from one day to the next, from one judge to the next. You could never, ever feel secure, right? Because you'd never know where you stood. Well, this was the huge problem that one man decided he had to solve. And that brings us to our first section here, justice without a map. I think that phrase just perfectly captures the kind of legal chaos that was common in many parts of the medieval world. There just wasn't a single clear guide for how justice was supposed to work. Just try to picture this for a second. Imagine you have a business dispute in one town, and it gets settled based on some local tradition. But then, just a few miles down the road, the exact same case gets a totally different outcome. This wasn't just, inconvenient. It was a deeply unjust system where who you knew mattered way more than the actual facts. This world was practically screaming for an architect of justice. So who was this architect? Well, in this next section, we're going to meet the civilization and the incredible visionary who decided that justice shouldn't be a game of chance. So our story takes place in the Fatimid Caliphate. This was a sprawling, powerful empire that really thrived from the 10th to the 12th century. I mean, its capital, Cairo, was a global hub for learning and science. But a sophisticated society like that, it needs an equally sophisticated legal system to match. And right there, in the middle of this period, a man named Al-Numan would rise to meet that very challenge. You see, at the very heart of this amazing empire, the legal system was really struggling to keep up with everything. All the trade, all the discovery. It needed to be just as organized and reliable as the empire itself. And that's where our hero enters the story, a man whose ideas were honestly nothing short of radical for his time. And here he is, Qadi Al-Qudat Al-Numan ibn Muhammad. Let's break down that title because it's important. Qadi means judge. So Qadi Al-Qudat means the judge of judges, basically the chief justice. He was the highest judicial authority in the entire empire. And he looked at this inconsistent, mapless system all around him and decided, you know what? It's time to draw a whole new map for justice. This quote says it all. It's his core philosophy. Justice is impossible when the law is unknown or inconsistent. Just think about that for a second. If the law is a secret, how can anyone possibly be expected to follow it? And if it's inconsistent, then justice is really just a lottery, isn't it? Al-Numan believed that for a state to be truly just, its laws had to be clear, they had to be accessible, and they had to be predictable. This was his guiding star. Okay, so with this powerful idea driving him, he set out to create the solution. And that brings us to his absolute masterpiece, the blueprint for law. His masterpiece was the Da'im al-Islam, which translates to the Pillars of Islam. But honestly, calling it just a book is a massive understatement. This was a monumental legal code, a whole encyclopedia of law that took him decades to put together. Its entire purpose was to bring order from chaos by creating a single, unified legal standard for the whole empire. And the scope, it was just incredible. This wasn't some abstract theory. No, it covered all the practical details of everyday life and government. It laid out everything: judicial procedures, the rules of evidence, commercial law for their booming economy, family law, even criminal sentencing. Al-Numan was literally building an entire legal universe from the ground up. But, a blueprint is totally useless if no one actually builds the house. Al-Numan wasn't just a scholar. He was a builder. And this next part shows us how he constructed what was, for his time, a truly modern judiciary. So how did he do it? How did he put these big ideas into practice? Well, he used 5 key pillars of justice. First, unified manuals. His huge legal code was sent out to every single judge. No more guesswork. Second, strict testimony. Clear standards for evidence to fight corruption. Third, record keeping. Decisions had to be written down, which created accountability. Fourth, and this was a game changer, an appeal system, a way to check any single judge's power. And finally, judge training, to make sure the judiciary was professional and educated. And that right there is the key. This wasn't some philosopher's dream. It was a real, functional operating system for justice. These 5 pillars created a system that was predictable, accountable, and professional, and it was rolled out across an empire that stretched all the way from Egypt to Syria. The scale of this achievement is it's staggering. So, this brings us to our final section, where we really see the true significance of Al-Numan's work when we put it into historical context. This was a legacy that was truly, truly ahead of its time. I mean, just look at this comparison. It really puts it all into perspective. In the 10th century, the Fatimids had unified legal manuals and administrative courts. Meanwhile, over in much of Europe, justice was often decided by local custom or sometimes even by trial by ordeal. The kind of professional legal system Al-Numan designed wouldn't really take shape in most of Europe for centuries. It's a stunning example of how advanced this civilization actually was. So, the result of all this incredible work, the blueprint, the 5 pillars, the vision, was one of the most sophisticated and professional legal systems in the entire medieval world. Al-Numan's quest for certainty didn't just reform a system, he built a brand new one, and in doing so, he established a standard of justice that was centuries ahead of its time. And that leaves us with one final thought. The principles that Al-Numan championed, the idea that laws should be known, that they should be consistent, and that they should be applied by trained professionals with some kind of oversight, well, those are the cornerstones of modern justice today. So the question is, how does this 1,000-year-old quest for legal certainty still echo in the halls of our own courts today? It's
talking about justice and this really timeless idea about who actually gets to have the final word. It's going to be good.
So, what does a 10th century Fatimid judge have in common with the modern U.S. Supreme Court? I mean, on the face of it, that sounds totally impossible, right? You've got a judge from the Fatimid Caliphate way back in the 10th century, and then you've got the U.S. Supreme Court of today. You know, one was working with Islamic law, the other with the U.S. Constitution. 2 completely different worlds. And yet, and this is the crazy part, they both struggled with the exact same problem. When a law is vague, when it's not totally clear, who gets to decide what it means? And believe me, the answer they both came up with is pretty remarkable.
Okay, so let's jump in our time machine. We're heading way back, all the way to the 10th century. Our main character here is a guy named Qadi Al-Numan. Now, this wasn't just some random judge. He was a legal superstar of his time. Super brilliant, super influential, the chief judge for the whole Fatimid Caliphate. And his work, well, it laid the foundation for legal ideas that were used for centuries. So one day, this case shows up on his desk. And it was one of those cases, you know? The kind that was going to put everything he believed into the test. It was a classic showdown, the powerful against the vulnerable. So here's the setup. It's actually pretty simple, but the stakes couldn't be higher. You've got this powerful local governor, and he's trying to seize property from orphan children. I mean, we're talking about literally the most defenseless people in society. And his excuse, his justification, was the super vague catch-all phrase, "It's in the state's interest." You've heard that one before, right? It's the timeless excuse for a power grab, this idea that the government can just steamroll individual rights whenever it wants. So the whole case boiled down to one single question. Can a government official's personal opinion just override the actual written law?
So, faced with this clear abuse of power, Qadi Al-Numan's ruling was just a masterclass in clarity. First thing he says, and he's totally unequivocal about it, the state has no right to take legally protected property. Full stop, period. A governor can't just make up some state's interest excuse out of thin air. Second, he gets right to the heart of the problem, uncertainty. He argued that when laws are vague, it's basically an open invitation for tyranny, because it lets rulers do whatever they want. And finally, he lays down the solution. Officials are servants of the law. They are not the law itself. They have to bow down to what is explicitly written.
And this all gets summed up in this incredibly powerful quote from him. When the law is written, opinion must surrender to text. I mean, wow, that's the bedrock principle right there. It sets up a clear hierarchy, right? The written law is at the very top, and the personal opinion of some official, no matter how powerful they are, is way down below. This is huge because it creates predictability, it creates justice, it turns the law into a shield for the weak, not just a sword for the strong. And this idea, this deference to the written law, became a cornerstone of Islamic law for ages. Now, I want you to hold that thought. Just pin it in your mind.
Okay, ready for another jump? Let's fast forward more than 1,000 years. We're leaving that 10th century courtroom, and we are landing smack dab in the middle of 1980s Washington, D.C., right inside the U.S. Supreme Court. Now, in our modern world, you've got these massive government agencies, right? The EPA, the FDA, they're creating thousands of rules that affect our daily lives. And guess what? The Supreme Court was facing a very, very familiar problem, just wearing a modern suit.
So this all came to a head in a landmark 1984 case, Chevron v. NRDC. The court basically established a formal rule for this exact problem, and it's called the Chevron Doctrine. Here's the gist of it. When Congress passes a law, but it's kind of vague or it's silent on some specific detail, the courts shouldn't just jump in and make up their own minds. Instead, they have to defer to the expert agency that's in charge, as long as that agency's interpretation is reasonable. So think about it like this. Congress passes a big environmental law, but they don't list the exact safety level for every single chemical in existence. That would be impossible. So the expert agency, the EPA, fills in those details. The Chevron Doctrine says, hey, as long as what the EPA decides is a reasonable way to read the law, the courts should back off and let them do their job.
But, and this is a big but, this deference isn't just automatic. It's not a blank check. The court actually created a little two-step test. Step 1, a judge has to ask, did Congress speak clearly on this issue? If the answer is yes, then that's it. Everybody has to follow the clear text of the law. Game over. But if the law is silent or it's ambiguous, then you go to step 2. And that's where the judge asks, is the agency's interpretation a reasonable one? And notice the word there, reasonable. It doesn't have to be the only possible interpretation or the one the judge would have picked. It just has to be a permissible one. This whole thing is built on the idea that these agencies have technical expertise that, let's be honest, judges just don't have.
Okay, so now we have our two stories on the table. We've got a 10th century judge standing up for orphans against a powerful governor, and we have the 20th century Supreme Court trying to figure out how to deal with all these modern government agencies. I mean, on the surface, they seem like they're from different planets, but now we're going to put them side by side, and this is where that ancient echo we talked about starts to get really, really loud.
Just look at this comparison. It's wild. Al-Numan's principle says that an administrator's opinion, like that governor's bogus state's interest claim, has to yield to the written law. The text is king. Now look at the Chevron Doctrine. It operates from the exact same starting point. An agency only gets to have its interpretation stick if the law is unclear. Put another way, if the text of the law is clear, what the agency thinks doesn't matter. See? Both systems start from the exact same place. The written text from the highest authority comes first.
And this parallel, it goes really deep. I mean, you can go line by line, and the logic is pretty much identical. For Qadi Al-Numan, government officials have to follow the written law. For Chevron, government agencies have to follow what Congress intended. For Al-Numan, judges step in when officials abuse their power. For Chevron, courts step in when agencies go too far. At the core, they're both trying to do the same thing. Al-Numan wanted legal certainty to make sure there was justice. The Supreme Court wanted legal clarity so they could review what agencies were doing. Both of these frameworks were designed to do one thing: control executive power and tie it to the rule of law.
So you might be thinking, okay, that's a cool historical coincidence, a neat piece of legal trivia, but it is so much more than that. This parallel, it reveals something really fundamental about what makes for good governance, about the rule of law itself. And it doesn't matter if you're in the 10th century or the 21st, it speaks to a universal problem that every single complex society has to figure out how to solve. What it comes down to is this: both of these systems are trying to strike an incredibly difficult balance. On one hand, governments need experts in charge, right? Officials who can make smart decisions. But on the other hand, that power can't be unlimited. It has to be tied down, constrained by written law. So both Al-Numan's ruling and the Chevron Doctrine, they're basically just frameworks for managing that tension. They're a rulebook for figuring out when the experts get the benefit of the doubt and when they have to step back and just follow the letter of the law.
And this really brings us to our final big question. When should expertise defer to text, and when should the text defer to expertise? This isn't just some dusty historical issue. It is one of the most hotly debated legal questions happening right now. In fact, the Chevron Doctrine itself is under intense fire, with a lot of people arguing it gives these agencies way too much power. What this ancient parallel shows us is that this debate, it's not new. It's a timeless struggle. Finding that perfect balance between the rigid certainty of a written law and the flexible, real-world application of expert knowledge is a challenge every single legal system has to face. It's a question Qadi Al-Numan answered for his time. It's a question the Supreme Court answered for theirs.
Look at that delicate dance between a government's power to get things done and the laws that are supposed to keep that power in check. It's all about where you draw that line in the sand. Okay, so let's jump right in with a question that really gets to the heart of how modern countries work. You've got laws, right? They're written by politicians. Then you've got government agencies, the experts who are supposed to apply those laws day to day. But what happens when they don't agree? When an agency says a law means one thing, but a citizen or a business says it means something totally different? Who's the referee? Who gets the final word?
And that question leads us straight to this fundamental problem that every single government has to deal with. See, on one hand, you need your government agencies to be able to act. They need to be flexible, to use their expertise to handle complex stuff. But on the other hand, we live by the rule of law, the idea that nobody, not even the government, is above the rules. And, well, that creates a natural tension, a constant push and pull between getting things done and doing them by the book.
For a long time, a lot of legal systems have tried to solve this with a concept called administrative deference. And the idea kind of makes sense. The courts, who are generalists, basically look at a super specialized agency and say, listen, you guys are the experts here. You live and breathe this stuff. So as long as your take on the law seems reasonable, we're going to defer to you. We'll trust your judgment. It's a way to keep the courts from micromanaging everything.
But here's the million-dollar question, right? That deference thing works great for the small stuff, the technical details. But what happens when an agency's reasonable interpretation suddenly looks like it's stomping all over the country's constitution, the highest law of the land? Does being an expert give you a blank check to do whatever you want? That's where this whole idea gets really, really tricky.
So, let's turn to how Pakistan's legal system dealt with this head-on. Instead of just copying what other countries were doing, the Supreme Court of Pakistan decided to forge its own path. It set out to create a principle that could respect the expertise of government agencies, but also draw a very clear, very bright line that could never, ever be crossed.
And boom, this quote just nails it. It's so powerful in its simplicity. Let's break it down. The first part, courts defer to administrative interpretation unless unlawful or unreasonable, that's the nod to the experts. It respects the role. But that second part, but the Constitution remains supreme, that's the game changer. It's the ultimate trump card. It says, no matter how reasonable your idea is, it can't beat the Constitution. Period.
Now, a powerful idea like this doesn't just appear out of thin air. It has to be built, brick by brick, in the fire of real-world court cases. The Supreme Court of Pakistan had to tackle this in some major legal battles, cases that really pushed the limits and helped establish a solid foundation for this entire way of thinking.
What's so interesting when you look at these cases is the time between them. You've got one from 1999 and another from 2016. That's a 17-year gap. That tells you this wasn't just a one-off idea or a passing thought. It's an enduring legal philosophy that the court has come back to and reinforced time and again. It's become a true cornerstone of the law.
So what's the core logic driving all of this? In the legal world, they have a fancy Latin term for it, ratio descendandi. All that means is the reason for the decision. It's the simple, elegant thread that ties all these rulings together. And in this case, the Supreme Court boiled it down to an incredibly clear formula for how government and law should work together.
I mean, just look at how clean and powerful that is. It's like a three-legged stool for a stable society. First, law must be clear. That's on the lawmakers. Don't write confusing rules. Second, administration must follow it. That's the government's job. Your duty is to follow the law, not bend it. And third, courts must enforce it. That sets up the judges as the ultimate guardians, making sure everyone else does their job. It's a perfect system of checks and balances.
And believe me, this isn't just some abstract theory for law professors to debate. This idea, this demand for clarity, has massive real-world consequences. It affects the everyday life of every single person, it impacts the economy, and it really shapes the character of a nation. This is where the law jumps off the page and into our lives.
So what it really comes down to is this. The clarity of a country's rules can pretty much determine its destiny. Think about it. When the rules are clear and predictable, businesses feel safe to invest. People know where they stand. It creates stability and prosperity. But when the rules are vague, when you have to guess what's allowed, well, that's a recipe for corruption. It becomes about who you know, not what you know.
And that really is the ultimate point here. We often think of the law as this complicated thing that only lawyers can understand. But the core idea we've been talking about is actually super simple. Having clear rules that apply to everyone, including the government, isn't a nice-to-have. It's the absolute bedrock. It's the foundation you build everything else on. Without it, the whole structure is shaky.
So, let me leave you with a final thought to chew on. This whole principle isn't just for nations and constitutions. It applies everywhere. Think about the rules at your job or in your local community. Are they clear? Do you know what's expected of you? Or are they kind of vague, leaving you guessing? Because as we've just seen, that one little difference, it changes everything.
Thank you so much for joining us for this explainer.
A special thank you, of course, to Mr. Zahir Ahmad Mir. His research and writing gave us the foundation for this whole discussion today. It's his work in making these